Hello and welcome back to the channel to another of my interviews. Today I'm going to be talking to two distinguished guests. You may remember we've talked quite a bit about common law, natural law, all of those things, and you may remember all of this was kicked off by a gentleman called William Keyte when we were talking about constitution and the fact that a lot of people are unaware that we have a constitution or that it has the power that it does. And so many of you have said, can we have William back again? And so, of course, by popular demand, I said we can. But not only that, William has brought a colleague of his, John Locke from Australia, and we're going to find out about how this works across the Commonwealth rather than just in this one country. So let's bring them on. First of all, we've got William Keyte, of course. Hello, Will. How are you?
Very good. I'm in good form. Thank you very much, Richard. It's great to be back on.
Fantastic. And we're going to go to the other side of the world, down to Australia, to John. Hello, John.
Hello there, Richard. Thanks very much indeed for inviting me on. And it's a great pleasure to be working with Will again. We've been talking quite a bit recently.
It's lovely to have two different perspectives on this. I must ask, the mountain that you are sitting behind there looks very lovely. Can you tell us where that is?
That's just the view from my patio at the back there. No, not really. I'm joking, but it's just I don't know where it is actually. It's just a scene I like. I have it as wallpaper on my PC, and I thought it would look better than as a backdrop than the stovepipe and the light in the kitchen. That's really at the back on me. So.
You've blown the myth. You could have been somewhere, up there in the Himalayas.
I think your stovepipe and kitchen looks very nice, John. Actually, I don't think you should.
Anyway,
I refer to it as Mount Olympus. Anyway, yeah.
Mount Olympus. There, that will do. As long as it's your stovepipe that's producing all the smoke and not the mountain, we're all right. Anyway, so Will, you sort of very much in control today. I'm just here to sort of make sure that you two boys don't cause too much trouble and get me banned again. So we're going to be talking about the Commonwealth and the Constitution within that, and then Article 61 from the Magna Carta. So, yes. Will, do you want to kick us off?
Yeah, I mean, absolutely. By just an introduction to John, really. Because both of these topics are very much to do with the work that John is doing along with Fitz in Australia, and there are others also doing this. And it's there are really two topics that we want to look at today. The first one is the Commonwealth countries and how they're affected by our common law constitution, because we haven't really touched on that enough. So we'll start with that one, and the second topic is about Article 61, which we need to go into, which is the lawful rebellion common law article.
It's the one that everyone quotes, isn't it? You always hear them saying, "Oh, Article 61 this and Article 61 that."
Yes,
and perhaps people don't really fully understand it, so that would be great to go into it.
Yes, and there's some complexity behind it too as well, which we'll come on to later, but absolutely, and John's the expert on that, and we'll go into that. But the first topic, because John is in Australia, he deals with the slight nuances that we have to deal with our constitution as it relates to Commonwealth nations, and there's some little bit of added complexity there. Because of the extra fun and games that are played by the establishment in the respective countries as well. So, John, over to you. Get cracking. Go for it.
Okay, thanks very much, Will. Well, I suppose the first point to cover is really just to emphasise what Will's just pointed out. The British Constitution covers the entire Commonwealth. There are 64 countries who the Constitution applies to. These just a list of the 64 Commonwealth nations. They're all able to avail themselves of the provisions of Article 61. But as a bit of a sort of grounding, we need to get a couple of principles out. First is that the Constitution is not the source of our rights. Our rights are there from the time we're born. It is a written statement which binds the government. so that it may not breach those rights without acting unlawfully. That's an important distinction.
Yes.
We don't actually look to the Constitution as a provider of our rights. They exist from the moment we're born.
Absolutely.
Yes. So, the people are bound by the common. Sorry.
I was going to say, is that, I mean, because man has written the Constitution, that man then has to be above it. Because
yes,
that's right.
The key to it is that it's less a contract, because some people, I think of it as a contract. It's not a contract. It's a one-sided promise to bind the government.
Mm.
And the idea being that it leaves the people in their natural space, functioning under natural law, really as anarchists, essentially. It's an anarchist lifestyle for the people.
Self-governing.
And the Constitution is only compels the government because it's a one-sided promise. So don't think of it as a contract, because it's one of the things that somebody that you were interviewing recently, I can't remember who it was actually, was not understanding.
Sovereign Pete. Yeah, I think it was
one of those
Pete.
guys, and they're all great guys, and they're doing some good stuff actually. But it's important to understand the Constitution doesn't bind the people so much; it's the government that it's binding.
Right, which makes so much more sense.
Yes.
Yeah.
Sorry, John. Go on. Go for it.
The people are bound by the common or natural law, right, which is often referred to as God's law. That means it's summed up by the Ten Commandments and the Golden Rule. In other words, we're free to do basically what we like as long as we don't hurt other people.
Mm.
And the Constitution doesn't prescribe any action on the part of the subjects, the crown subject, only in one instance, and that is, we'll come back to it, is given in Article 61. When the monarch becomes charged with committing or failing to prevent treason, that's when that comes up.
Right.
So the basic moral principle of the Constitution is every living subject is a sovereign being. We have rights to liberty and self-sustenance. They're born with it. Just the same manner and the same reason that animals or plants all have those rights. Every living thing has the right to sustain and preserve its own life.
Yeah.
So there are people who... Sorry?
No, I was just going to interrupt because somebody said to me the other day, it's funny how animals, you don't charge animals to live in their burrows and houses, but we get charged as humans by our governments to live in houses. And we're all equal, well, in our own species, but on the planet. I mean, we're all sharing it. So I was just sort of adding to John's point, really.
Yes, but there are those who seek to prey on the efforts of others, right? And the worst offenders in this regard, because they're granted a monopoly on the use of force, are governments, the groups that we call government. Mm. That's why there are constitutions, to limit these people. Most important of all, that's why constitutions cannot be written by the government. They must be written by the people, and they bind the government.
Spot on. Nice one, John. Absolutely.
Yeah. And as I said, that makes so much sense.
Yes. Well, it's all, when you think about it, it's very simple. In Australia, though, the situation is complicated by the fact that there is a written constitution here, which some of the people are aware of. Actually, there's a huge number of Australians who aren't aware we have a constitution. Some of them say, "Oh, isn't that an American thing?" They're just not aware that we have one. There's a growing number. The problem with it is that it was established by the Commonwealth of Australia Constitution Act 1900, which is an act of the UK Parliament.
Right.
And that renders it invalid from the outset. There were constitutional conventions held in Australia for a number of years during the late 19th century. And a submission was made to Queen Victoria to have the articles agreed upon incorporated into an Australian constitution. However, this was returned with over 70 alterations, which the people had not authorised. Right. This concept was sold to the Australian people with many materially relevant facts and principles omitted in a referendum. But as we were aware, if you omit relevant facts when seeking an agreement, then that constitutes fraud and invalidates any sort of contract or agreement. You can't just seek consent from someone to engage in a trade or whatever agreement you have, and if you withhold relevant facts. So this was something the average Australian in those days was not aware of these, the complications involved in constitutional law. An example of the fraud is shown in Section 71, which grants sovereignty to the Parliament of Australia to establish the High Court, which deals with constitutional matters, and quoting here, such other courts as it creates, and in such other courts as it invests with federal jurisdiction. So this is despite the opening phrase of the document reading, "We the people."
Yes.
The sovereignty is granted to the Parliament. Now, only people who are uneducated as to the true principles of constitutional or natural law could be persuaded to accept such an overriding abasement of their inalienable rights. It's an open license, really, to establish legislative tyranny, which after 120 years is now all but in place. Gradually, over the 120 years since that constitution was instituted, more and more power has accrued towards the federal government. And the states have less. The states had a big part to play in the recent health scare that we're all aware of. But this situation worsened in 1973. The Whitlam government illegally sold the Commonwealth of Australia to the US Securities and Exchange Commission as a business enterprise. There's still a huge number of people in Australia who are unaware of that.
How do you sell? So just say that again, so we get the full context.
They sold the Commonwealth of Australia to the US Securities and Exchange Commission under a 1934 Act in the US,
right? And
as a business enterprise. So if you look up Commonwealth of Australia,
you're now a corporation.
Yes, it's there in the US Exchange, and it's got a reference number and everything. We actually present this information to people in the notices that we provide them when we notify them that we're standing under Article 61 and that they're acting unlawfully. Now, this was all done hush hush. Nobody was told about it. Of course, it gradually became known to a few people. But despite the fact that obviously government people must have known about it, no succeeding governments have tried to rectify that situation. They've only made it worse. Both parties have gone along with this. And we've now reached a point where both the major political parties in Australia have policies which are virtually indistinguishable, which obviously makes a mockery of the idea that democracy is brought about by voting. So there's no legitimate constitutional process whereby the Crown can become a corporation and presume jurisdiction over the people. Under the Constitution, as Will's explained it already, the people are all sovereign.
Yes.
The monarch is just elected to perform the duty of protecting the individual's rights and liberties and the, what's the word I'm looking for? The stability of the nation, preventing it from, foreign takeover and that sort of thing. So the king, even the king, doesn't have the right to capriciously command someone to do something that would violate their inalienable rights. If he did, they would also have an inalienable right to decline and say, well, you're the first among equals, but you're not actually the boss.
No.
Your job is to make sure that nobody offends me, and that includes you. So that's putting it in a sort of a nutshell.
Yes.
Absolutely right.
So, I mean, an example would be one of the people you had on recently, Richard, pointed out about, for example, if McDonald's put leaflets through your letterbox saying, look, from now on, we require you to spend $10 a week on McDonald's products. And if you don't, there'll be a fine or you'll, we'll lock off your driveway so you can't go out until you've paid us. Some sort of penalty like that. And we would just say,
we'll put a stinking great big Mac on your driveway.
Yeah, so obviously we would just say to people, well, look, sorry, where's your authority to do that?
Yeah.
And it's the same with these people now that they're acting, they're corporations acting. Every court, every police force every government department in Australia is a corporation with a registered Australian business number.
So does that
So
not limit
no,
what they can do? Does it, I mean, if they're a corporation and they're just putting, say we want your taxes, you've got no agreement, you've got no contract with them to do that. So when people know that they are these corporations and that's how it operates, they, in theory, should be able to say, well, no, thank you very much. It's very kind of you to demand some money from me, but I'm really not interested. But if you were a legitimate government who was here by the people to do the stuff, then yeah, we would do. But
exactly.
You're not.
Quite right.
That's
yes.
exactly what we say to them.
Right.
Now, of course, they don't like it when we say that.
No, I bet they don't.
They try to harass, threaten. They do all sorts of things. I mean, it extends to virtually everything the government does, and especially the thing that gets most people, I suppose, is when we're punished for something that we've done, some infraction of a piece of legislation that we haven't actually hurt anyone. For example, we might commit a minor traffic infringement. No harm is done, but we get fined $150 or $300, whatever the penalty is. And when we say to these people, we put them on notice, we say, look, I'm standing under Article 61. It was invoked in 2001. So that suspended Crown authority. And unless you can prove that you've got Crown authority and that I'm mistaken that Article 61 is not invoked, then, I'll willing to comply with your demand, provided you can do that. But if they can't do that because it was invoked. So it gets to be a point where they start to threaten and harass people. And it's the individual's always got the option of complying under duress. We explain to them, look, I've sworn an oath to uphold the Constitution, which the current government is not doing. I don't want to break that because that would be, as far as I'm concerned, committing an act of treason. But if you force me, well, I don't have much option. It's on you. This will all be recorded. And eventually, when we get trial by jury and proper courts established, you will be summoned to one of those courts and have to answer for the things that you're doing, which are crimes.
Yes.
And so this is a process which, when people first hear about it, they think, oh, gee, that sounds, it's sort of a bit mind-blowing, The first person who was explaining to me about Article 61, which was the first contact I had with learning about the Constitution, I thought, well, is this person all there, But when you learn more, when you look into it, you find out, yes, it's all exactly as they say it, easily provable.
Is one of the problems that the people who are employed by these corporations do not, the lower ranks of people do not know that this situation is like that. So you're standing there arguing the case and saying, well, actually, you don't have the authority to do this, by the way. And they are so indoctrinated with how it all works and cannot even conceive that there could be another way of looking at this. So presumably that's half the problem.
That hits the nail on the head. Yeah, that's it. That's exactly the problem. The high-ups
that is largely the case, and I would say, Richard, as I've said before, that they pulled this off largely through miseducation and gaslighting.
Yes.
The people within the system, to a varying extent, depending on their position and what sector and what department, what agency of government we're talking about, are knowledgeable or not to varying amounts. And I would also say, and it's important to emphasize this actually, that there's probably a bit of a difference, a bit of a contrast between what's going on here in the UK and in Australia. I think, John, you'll probably agree with me that I think that things are probably more contrasting out there in Australia, in that you are in a worse situation, in that that contrast is a little bit more obvious, and that the behaviour of government agencies is probably more shocking over there than it is here. I think you've progressed further and slid down that road of tyranny. I think here we're a little bit protected by the rather sort of the Middle England spirit. That frankly we're not putting up with that sort of behaviour. We don't do that here. It's not polite. It's not, and actually, it's surprising how effective.
It's not cricket. It's just not cricket.
And it's surprising actually how effective that is, because the people within our systems kind of still respect that sort of fair play and that sense of decency. And I don't know, John, but maybe things have got a little bit more contrasted out there. Do you want to talk about that at all?
Yes, I think because one of the confusing things is, as I say, the existence of the written Australian Constitution, because a great many people, when they see these things that we're talking about, this overreaching the mark by the government, when they try to deal with it, they refer to the Australian Constitution, and there were all sorts of different approaches to that. There's all sorts of people running around. Some of them are in Parliament that refer to the Constitution, of course, but there are others as well, what you would call members of the freedom movement, and they propose various sort of methods of dealing with this. But the problem is the Australians have got more of the Australian government and their corporate bodies feel they've got more of an independent hand because of the existence of this constitution and the fact that there was an act passed in 1986 called the Australia Act that more or less declared Australia to be a sovereign independent nation, but doesn't really have any validity, and it was invalidated as well, along with all other acts and statutes when Article 61 was invoked. So a lot of people here refer to or quote from the 1688 Bill of Rights as a source of protection from government, but that's not really all that viable. The Bill of Rights is treasonous for a number of reasons, the main one being that it declared the denial of royal assent to be illegal, and insisted that the monarch become merely a figurehead. Indeed, the coronation oath act stipulates the monarch swear to govern the people according to the acts and statutes of Parliament.
Absolutely correct. And John,
this is an arrogation of Parliament to supremacy. It's nothing other than a usurpation of Crown authority.
Yeah. It's a common mistake over here, John. You're absolutely right that the authority is given to the Bill of Rights, which is itself only a statute with an unsigned declaration within it. But it was all, very. As I've said before on interviews, don't look to the Bill of Rights and the Declaration as an authority to the Constitution. You've got to go further back to Magna Carta 1215. That's when they get worried and scared behind the scenes, is when you know that and you're looking back further to the foundation, the founding. It's not really the foundation of our Constitution. As John rightly said, our Constitution existed prior to that, but it's the last declaration. It's the last expression that's written, and it's absolutely solid. So, sorry, I interrupted you, John, but it's great. Good point.
No, that's fair enough. Thank you for that. So that the Coronation Oath Act, as I say, is trying to get the monarch to swear to govern according to the acts and statutes of Parliament. And to her credit, Queen Elizabeth II omitted that phrase in her coronation oath and included correctly the phrase according to the laws and customs of their peoples, referring to some of the Commonwealth nations while she did so. However, that was as far as she went. Right. And she never once denied royal assent to any of the treasonous acts of succeeding UK governments, which granted increasing degrees of sovereignty over British and Commonwealth subjects to the EU. That was what triggered on March the 23rd, 2001, the invocation of Article 61 of Magna Carta. It was the House of Lords, the barons that were charged with protecting the Constitution in the event that the monarch failed to do so, quite rightly pointed out, we can't have the European, any foreign body, coming in and assuming sovereignty over Britain. That is absolutely forbidden, not just under the Constitution, but under various acts like the Act of Supremacy and so on. So Article 61, we're sort of gradually moving towards that now. Effect was to constitutionally depose Queen Elizabeth and suspend Crown authority. And of course, they decided, well, this is, we'd better keep this quiet. Let's keep quiet about this. Once you expose a criminal's actions as criminal, I'm not openly stating the Queen was criminal, but the people who are running the government act in that way. They have to resort to audacity. Once you catch someone red-handed, they can either say, "Oh, it's a fair cop," or "No, it wasn't me. I was somewhere else, and I'm just going to carry on. I'm not guilty." They just become audacious, or they cop it. So they decided to become audacious and just carry on as before. So
they seem to have their own version of what to do, don't they? Just double down. As soon as you catch them out, they reckon they'll just double down. And if everybody says this lie, then eventually everybody will believe the lie, or it'll be so big and we've got so powerful that even though you know it's a lie, we're still going to do it because we've got all the police, the army, and all these things. So you better keep quiet about it.
Shall I do a quick Shall I just do a very quick introduction on Article 61? Just give a quick background behind it first.
Please
quickly.
do.
So the Article 61 is one of the articles of common law in our Constitution. And it's one of the few, as John rightly says, it's one of the few articles that actually purports to compel the people. Now, it is actually compelling the people, but it's not doing something legislatively, because what it's actually compelling the people to do is what they would already be compelled and expected to do under the universal natural law. Okay, and that's why it can do it. Because remember, I was saying earlier that the Constitution, because it's not a contract, it's not really binding on people. So the only thing that it's compelling people to do is what they would be expected to do under natural law. And what that is that if effectively the government goes rogue, which is essentially what has happened, and that Article 61 is invoked, which just simply means it brings it to the table through some recognized mechanics within the administration, then that's the point that sort of triggers the action, if you like, within the people, that what you are supposed to do is to call out the lie. That's basically what it's essentially saying in principle. You are calling out the lie openly, and you are moving your allegiance, if you like, to the power that is then held by the barons, which is the power of the Constitution. The principles of the Constitution are then held by the barons because the crown has effectively delegitimised itself. That's essentially what is happening. Okay, and so the people are compelled to do that even under natural law, because all you're really doing is calling out the lie and standing for truth.
Wow.
That's really what it is at the principle level. You are standing for truth, and you are expected to do it openly, and you are expected to do it in some form, in some way that is open and not so much public, but it's an expression. It's a clear expression of your allegiance to truth. That's what it is. It's really quite deep, actually, in what it's doing. Now, what actually happened was it was invoked on the 23rd of March 2001, when 25 hereditary peers of the realm, that they started the process. 4 of those are then meant to petition the Queen, which is what they did. The Queen then replied through Sir Robin Janvrin, I think it is, isn't it, John? Who was the Queen's secretary at the time. And that invocation of Article 61 was reported in the Telegraph. It's a real deal. It's the real thing. It actually happened.
Yeah.
Okay.
And relatively recently, And relatively recently.
Yeah. And those things would not have happened if it was not the real deal. You wouldn't have got it in the Telegraph, and the Queen's personal secretary would not have responded. Now, I just wanted to reintroduce what John is doing, because John's heavily involved in Australia with Fitz on Article 61. But there's a key thing that I want to point out here, which is, in a sense, one of the reasons why I haven't raised it yet. Because Article 61 is kind of like the delivery mechanism, or the wrapping by which you show your allegiance to the principles of the Constitution. Now, it's my belief that you can't do that until you understand the substance of the Constitution. Hence why, when did we start this madness? Back in February, or whenever it was. I said that it was an education exercise first, because what is absolutely critical before you start taking any procedural actions on any of this under Article 61 or anything else for that matter, is you have to understand the substance of the Constitution. What are you fighting for? Okay, and what we're fighting for is the sovereignty of the people. And the sovereignty of the people is gained through jury independence and trial by jury. Now, the problems that I've seen in the past is that there are many involved in the Article 61 movement who have not even understood what the Constitution's actually about.
Right.
And I've even heard of people taking action under Article 61 who didn't even know we had a Constitution.
Oh, no.
Which is interesting, given the fact that Article 61 is an article of our Constitution. But anyway, I'm just pointing that out, But this is a problem. Okay, now the wonderful thing that John and Fitz and others are doing over in Australia is that they are taking or encouraging people to take action under Article 61. But they're doing it at the same time as teaching people the fundamentals of the Constitution and how it relates to natural law and our obligations in the universe, our obligations to truth. And that is absolutely paramount. There's no point in taking action under Article 61 unless you understand the substance.
Yes.
And so the guys over there are doing some really great stuff. So over to John.
Is that so?
That's my
I mean,
rant for the-
that's brilliant. And is that because you said before that Australia is in a sort of worse place because of the contrasting way the government have seemed to have been more? So they've been pushed into finding a solution, which is there in front of us through the 61, but understanding the Constitution, and that's something that we can learn over this side, this hemisphere.
Yes.
Need to learn because. We're in a
Yes.
similar boat, but perhaps just a little bit behind. So, John,
maybe just down to that. I mean, John, you can answer.
Yeah.
Is it the kind of the crisis nature of it that's actually kind of got you guys moving a little faster than? But it's not to say that people aren't over here too.
No, but also are people waking up more to it because of the circumstances you're in, John?
I think so, and all the restrictions and the infringements of inalienable rights that came about during the pandemic era, they really woke a lot of people up, and they started, hang on a sec, you mean I've got to have this treatment, otherwise I lose my job. I mean, these are all sort of things that were going on over here, and people were waking up to it. It made it a lot easier for us to get the word out. The point that Will made that I want to amplify is that when we see that it's the moral question, when we see any crime being committed, we have a moral obligation to speak out or act against it. If we see somebody abusing a child in the street or committing an act of theft or something like that, we're obliged morally to say, hey, you shouldn't be doing that. We're protecting everybody's inalienable rights when we speak against one instance. So this is very important that we do this with these government bodies, that we call them out and say, look, you really can't carry on like this. Now, how do we do that? That's the question. This is where we get back to David Robinson, and he was working with a lady called Elizabeth Beckett. They devised a series of lawful notices, which we send on a recorded basis. We send them by recorded mail to alleged officers of government if they're making unlawful demands on us, or even before they do so, we can let them know, look, I'm standing under Article 61. So if you're thinking about in the future making some demand on me, you're going to have to verify that you've actually got the authority to do that. These notices are worded so that they're discernible to those in the legal profession as being in accordance with their usual codes of honourable behaviour. You know how they all talk in court, my learned friend, the honourable gentleman, and so on. They make a great show of that. So it was necessary to get these notices worded in such a way that they were understandable to people coming from that sphere, but also brought the lawful aspect of what we're talking about, the Constitution, onto the same plane. Once you've got the lawful and the legal on the same plane, then the lawful can exert its authority over the legal, because it always has the ultimate authority.
Yeah.
Anything can be declared legal by Parliament, but that doesn't make it lawful. Lawful things which are bound by natural law override everything else in the final analysis. So that's how we sort of start pushing back with this thing. We use these notices to let these people know, and the idea is we're letting them know, first of all, about Article 61. They get a full copy of it. They get all the evidence about the failure of the government to uphold the Constitution and their inalienable rights. We give them an opportunity we say, look, I'm not being belligerent here. I'm willing to comply with your demand, provided you can show me that Article 61 is not in effect. And if you can do that, well, then I'll do what you say. But of course, they can't do that. So they normally ignore those things. We give them another opportunity in this sort of the honourable code that the legalese profession uses. Give them another opportunity to respond. They normally fail to do so as well. And finally, that we would then say to them a third time, well, look, you haven't actually rebutted what I've said, so I'm going to have to assume that you're giving, tacit legal agreement with what I've said. Now, eventually, obviously, I'm making a file of all of these proceedings, and if it winds up in a court of law, it won't be to your advantage, the fact that you haven't rebutted anything that I've said, which might well be standing in law.
And that's the same process they do to us, isn't it? It's exactly what they do to us.
Exactly what they do, yeah.
Yeah, so if you don't rebut their demands and things and say, well, whatever it is, then they're going to assume that you've complied.
That's right.
Yes, I do think just a caveat there, because under common law, the idea of making a statement and then them not rebutting it, all that's really doing is providing evidence. It's not binding like it is in law merchant or the Admiralty or the commercial type law systems.
Right.
Because remember that usually a jury is involved. So, if the police make a claim about a defendant, and the jury are watching, and the defendant doesn't really understand, or doesn't respond and doesn't rebut it, you're not necessarily going to say, well, oh, hang on, that they didn't respond, so that it must be binding. It must be correct then. No, it doesn't quite work like that. But what John is saying is that it doesn't look very good if they don't rebut it. It's pretty damn good evidence, and the whole thing about the
because they've got the chance to do that, and they just don't take it.
Yes, they got a chance to do that, and what John's really saying is that the procedure, the notice procedure that he's putting in place, the power of it is that it's providing evidence and of their criminality, and it's also providing evidence for your protection, perhaps later, against some accusation that you haven't stood for what is right. John.
So when it's in front of a jury, you're able to present that evidence that you've just mentioned and say, well, look, here's the evidence. We did ask them. They didn't say. We asked them a second time. They still didn't say. So we've said to them, well, as you haven't, we're going to assume it must be true. And
you agree with it anyway.
Yeah.
So that's basically the nub of it. Now we continue on. There are a couple of other notices after that. One, the fourth one we send is to say, well, you haven't disagreed with anything I've said so far. They may have disagreed in a letter or some response, in which case we rebut that. We always rebut any response that they might make that our claim is not correct. The fourth notice would let them know, well, look, you've been advised that there is treason being committed, and you're actually a part of that. So this notice is letting you know that you're committing the crime of misprision of treason, which is concealment of treason. You are supposed to report this to the authorities that are dealing with it, are supposed to deal with it. But it might be the police, it could be a justice of the peace, whatever. If you don't do that, this is just another thing that you're doing, adding to your catalogue of crimes that we've already noted. Yeah. And the final one is just a notice to them, just to stop what you're doing, stop harassing me. I'm standing within the law. And if you don't stop, I may have to take action against you at some time in the future, maybe even before the trial, because you are committing a series of torts. They're committing many torts with these things. The tort of trespass, a sort of assault, threatening people with something is assault, demanding money with menaces, fraud, pretending to be a Crown agent when you're not, misrepresentation. There's all sorts of things, and we let them know about these in some of the letters we send them. So this is the method that we use. Now, everybody is not obliged to use that method. It was something that was devised by David Robinson and Elizabeth as a great help to people who, like myself, didn't come with any legal background. Most people don't have very little knowledge of how the law works, even what the law is. So this process, these notices help with that, and they also provide a record. Even when we send these, we even include those of us who have done a written oath. We include a copy of that to them to say that this is the oath that I've sworn. You can see this is where I'm standing, and it's in accordance with the constitutional law as it was invoked. So,
can I just say actually that although and it's important just to make the point that actually Article 61 doesn't say how we should do this, but this is a very complete process. So what John is describing here is a series of notices that are perfect as a record, as I've already explained. And there are some impressive exhibit documents that are put in there as well. So one of those, for example, is the FCO 30/1048, which is a document that was released. It was actually classified until relatively recently. I obtained a copy of it years ago, at the time when I shouldn't have had it.
You rebel.
I know. But it's actually got, it contains some fairly jaw-dropping stuff, and one of them is an interesting letter back from Lord Kilmuir, I think it is, a letter back to the Heath government advising them of the treason that they would be committing if they went into the EEC. It's quite amazing stuff, you know.
And they did it anyway.
Yeah. So there's some important stuff here. So credit to these guys, because they're and to Dave Robinson, who I did know for a short time. I wished I'd known him for longer, actually. But he did a lot of work. And the other thing, actually, just to say, is that I will put a letter up as one of the resources on commonlawconstitution.org that Elizabeth Becket wrote to the Queen towards the end of her life, calling her out on her unconstitutional reign. I'm sure John is aware of this one, but it's a fairly jaw-dropping letter, and it's written beautifully. And what that brings me on to is my own personal sort of favoured style, because actually going with the notice process that John is talking about is great. It's full of good stuff. But I personally, stylistically, prefer a simpler, shorter, more principled kind of letter, a simpler process. But that's only because that's just me. That's just what I'm like. And remember that actually you're acting this in natural law, so it's about principles. You're not compelled to do it this way, but I do think that the documentation that these guys have put together is very complete. And if people want to do it that way, absolutely fantastic. There's some really interesting stuff in it. But as I say, I will put that Elizabeth Becket letter up as well. Carry on, John. Sorry. Anything else you want to add?
No, thanks. Thanks, Will. So, yes, as you mentioned earlier, not long ago, what we're really aiming at, we want to get trial by jury in properly convened courts re-established. And Article 61 is just providing us that doorway that we can open to start on that path. That could possibly be quite a tortuous path. We don't know how many twists and turns are going to have to be negotiated as we move towards that goal. But this enables us to start. And the more people that we can get who can make their affirmation to support the Constitution, however they want to do it. In the old days, it probably would have been a verbal, since most people were illiterate in 1215. Or even today, for example, the people who are supposed to be constables, who are posing as constables, they swear their constable's oath verbally on the day of their graduation. Then they forget about it. It's hard to find a police constable who's actually living up to that oath, where they actually swear to preserve the king's peace and to treat everybody equally and not do anything to disturb anybody's peace. While they go busily about obeying these orders of their corporate masters and hedging us about and pushing us into corners. So for there to be a legitimate legal system, there must be a lawful basis on which it rests. You can't have a legitimate legal system, and we do need a legal system, but it must be lawfully based. If it's not, it's just a free-for-all. Whoever can get the biggest gang together.
Yes.
And that's basically what we've got at the moment.
So let me ask you this then, which has just occurred to me. How do you take a corporation to a court? Because you're really only able to take
That's a very good question.
The people,
you're not so much
employees.
You're not taking the corporation to court. In a way, this whole business about what they've done, is setting up these parallel systems. As I keep saying, we can sort of know that that's what they've done, but it's not what we should be focusing on. What we should be focusing on is how they should be operating, and then calling them out why they are not. You can say, as a subtext, I think you've been setting up corporations. I think you've been setting up parallel systems of government.
No, but I'm just saying, if you implement the trial by jury in front of 12 just men or however many it is, and it's run lawfully.
Oh, I see. Sorry.
So you've got the corporation, which is something on paper.
Yeah.
But only has employees.
Yeah.
So I'm asking.
That's the answer. Yeah.
Yeah, so
that's the answer to your question, Richard.
Yes.
We find out the name of somebody who's making the demand.
CEO.
We might get a demand from, a fine from a council for parking, or it could be for some other fine or fee that they want to levy against us. We have to find out who is making that demand. It's got to
individual.
Be a person.
Right.
And then we send the notices to that person. And we point out it's on you. You are personally liable for what you're doing. The fact that you might have a badge, a gun, and a costume that makes you look like a police constable. Doesn't mean that you necessarily are a police constable. If you're not acting like one, well, you're not one. You're just pretending. So it will be you personally that will be held liable in a court of a trial by jury when the time comes. Yes.
And that whole thing about being
obviously you can
ignorant
tell
of the
some
law.
of them don't get that idea, but some of them do get it, and they backpedal, they back off.
Because that thing about being ignorant of the law is no excuse, which is what they'll tell you. But if they're an employee and they don't realise actually by signing the document that we want the money from you for whatever it is, you're saying to them, well, actually, you realise that you're liable, and ignorance of the law is no excuse, mate.
Especially now that I've told you. Yes. And I mean, you really can only ignore something once you become aware of it, can't you?
Yes.
Otherwise, you can't be ignorant of something you've never heard of.
No, although that's how they treat you.
You don't know it's there.
Yes.
But now that we've told them, well, then they're answerable. Absolutely. Same as we are answerable. If we're told, don't do that or you'll be breaking the law. I mean.
So where do we go from here then? We've got the situation that both your country down in Australia and where we are, we have the tyranny of these governments behaving extremely badly. What is the next process? What do we do?
John, do you want to talk about destraining and distressing?
Oh golly.
Yes. In Article 61, it points out that when the barons finally take this action of invoking the Article 61, that we are supposed to distrain and distress the crown. And actually the wording says, let's see what I'll just, so I don't misquote. Right, here we go. Right. Let's assume that, okay, the The monarch has made no redress within 40 days, which is the time given to them to redress the matter. The 4 barons shall refer the matter to the 25, who may distrain upon and assail us in every way possible with the support of the whole community of the land, by seizing our castles, lands, possessions, or anything else, save only our own person and those of the Queen and our children. He's using the royal we here, the monarch talking. Until they have secured such redress as they have determined upon. Having secured the redress, they may then resume their normal obedience to us. So some of the original supporters of Article 61 did go so far as to seize buildings. I think David Robinson did one in somewhere in Somerset.
He was involved in the action in Glastonbury, in the taking of the town.
Glastonbury, that's right.
And in fact, Sandy Adams, who you've also interviewed, was involved back then as well, I think. So I wasn't on the scene back then, so I don't remember it, sadly. But I'd love to have been there. But yes, they took the town hall under Article 61, and the police were very decent about it because they understood, I think, what was going on, and they explained it to them at the time, and they handed it back a few hours later. Partly because the poor janitor was wanting to get home to his wife.
Yes, I've heard that. I just looked up very quickly the old meaning of distrain, just as a matter of interest, from Latin. According to this, it says to pull asunder, from to draw tight and strain. But it's now to take or sell property from someone who owes you money or pay back their debt.
Yes, but the main method that we use now is to simply withhold funding from them. If you try to seize buildings, they're quite likely to get an over violent reaction from the police. People will get arrested and that sort of thing. We simply let them know, hey, look, we're just not going to fund you. You're demanding this payment. You don't have any authority. I'm acting under Article 61. This is distraining and distressing.
And there may be, I mean, to be fair,
we're told to do it under any way that we can that's lawful.
Yes. Yeah, I mean, John, you're absolutely right, and funding is great, but actually back to the property thing, and it won't be a case of distraining and distressing castles and things like that, although that could be quite exciting. But it might be things that are movable in the sort of the 20-minute zone cities and things like that. Things that are blocking roads.
Cameras and plant pots and all
absolutely.
of those.
You've got 2 reasons for doing it, which is firstly the principle of it, that it's actually obstructing my free movement anyway. But secondly, we're going to do it under Article 61 because we're authorised to do it under the Constitution, because you are illegitimate at the moment. So you see, this is the point about doing this kind of stuff, is that you are morally supported in doing what you're doing.
Yes.
For multiple reasons, and for the reasons under the law as well. It's really powerful. So
what we need is for Will and John to put together a simple 1-page, easy to read PDF that just puts the bullet points so that people can start to do this. If they've got I'm thinking of the cameras and all of that, and just say, look, actually, we're allowed to do this because of these reasons, and the process that most people, because people will listen to a video like this and be thinking, wow, this is really good. Now, hang on a minute, what do I have to do again? Yeah. Because there's so much to take in, isn't there? And you can lose yourself down the rabbit warren of all these types of videos, but a piece of instructions that goes, 1, make this notice, 2, do this.
We have that already in place.
But hang on, Richard, that's what we're guarding against. See, that's the key, because otherwise the problem is that people just think, okay, what do I have to do? I just need to do that, and that. Great, fantastic, I'm sorted. No, you need to understand at a fundamental level what you're protecting. You cannot do this.
No, but that would be part of your. But that would be part of your process, isn't it? If the process is, you start here, you've got to understand this, and these are the basic tenets, and you understand that. It's only then when you've kind of ticked all the boxes and passed your own personal test, and you go, right, I've got it. I know why we're doing it. I know the history a bit behind it, and I know it's moralistically right.
Yes.
They don't have that, and it's part of the natural law. Now we move on to the second bit, was where we can express that to them and say, you don't have the right to do this, by the way. And then the third thing is, as you haven't done anything against it, well, we're going to distrain and whatever the other
Distrain and distress.
And distress. And your cameras are coming down, thanks very much, or whatever it is. Your castles have gone. We're taking the door away of number 10. You can't lock yourself behind there.
So we have these points of contact, Richard, where people can contact us. I'll send you the links and so on. You can put them into the box before you publish. And where they can come and get this sort of information.
Absolutely,
questions.
Yeah.
And,
I just know what viewers
this
are like.
education process. This is what Fitz and I have been working on. Fitzroy's done a fantastic amount of work. He's the leading thing. I'm basically a wingman for him. We have a Zoom meeting like this every Tuesday. In fact, the one's already going on now, which Fitzroy's attending, where we've got a group of people who are involved in the movement, and we talk to each other and help each other out with various things. We compose letters for each other. We discover whatever else we can to learn about the lawful process. So the aim of that is to be able to get this information out to a lot of people. The hardest part, Richard, is so people have trouble getting their heads around the fact that there could be so much crookedness or so much criminality in what's going on. People just have trouble getting their head around that because we've all been taught all our life, well, the government's there to look after you.
Yes.
The law's there to protect you and so on. To understand or to get in your mind, actually, it's completely the opposite.
Right.
They're completely screwing us. And
so in a way...
As Bertrand de Juvenel said, a society of sheep must in time beget a government of wolves. So sorry,
true. So I was going to say, so let me just revise what I just said, because that's a very interesting point. In a way, what you need is the people who've got the knowledge in your groups almost setting up community conversations where people come in, they listen and go through, because like what we've done here, but then at the end of it, once they've understand, they've had time to understand how powerful the indoctrination has been, and slowly realize actually, they can't do this, they shouldn't be able to do this, and you have to think differently about why they're doing this. And then these are the steps that you take, rather than perhaps just as I flippantly said, here's the instructions and away you go.
Yes, correct. No, that's absolutely spot on, Richard. And deep within that process, as John will know only too well because of what they're doing, is this self-reflective nature of the process, the fact that we are actually a part of this problem ourselves. Because when we talk about natural law, and we just throw that term out there, and I haven't really had a chance yet to get into this material more deeply, which I'm going to be on commonlawconstitution.org. But it is about this self-reflective nature. It's about our relationship between truth and lies. Okay, and often it's about the fact that not doing something in defense of truth and the need for calling out lies is absolutely as important, and not doing it is committing a crime under universal natural law.
Right.
And that's really profound. And that's the kind of stuff that you guys over there, John, are going into with Fitz, because that's the deeper level reflection that is needed. It's not that surface process.
No.
Without that real understanding, you can't understand your sovereignty and reach the point of your non-compliance until you start to go through that, facing your demons, facing your prejudices, understanding your own relationship with lies and truth. And the tendency that we have to sort of exaggerate and justify and play down, and we're all lying to ourselves a lot of the time, and it's those things, it's those little lies that have ultimately contributed to us outsourcing huge portions of our lives, that has then resulted in the government coming in and filling that void that we've left by not being strong and setting boundaries and being honest with ourselves, that's the thing that's contributed to the condition that we're in.
Wow.
And that's the kind of stuff that people need to get into underneath, that underpins constitutional law. So it's not a quick one.
No, I appreciate that.
It is fascinating.
Although we don't have a huge amount of time.
No, we don't. But once that process is started, it becomes conscious.
Right.
And it's the consciousness.
And there's no turning back.
There's no turning back.
Once you wake up.
Yes. It's the consciousness of it that is the healing aspect of it.
Right.
You don't have to do all the healing. You don't have to go through the whole journey, but you have to start it. And it's the recognition and the acknowledgement that we actually are a big part in what we've put into play here.
So this is I mean, this conversation that we've had here is sort of adds to what we've had before, and you could have the same conversation just nuanced differently, and it would all help hopefully sink in, because as we said before, the indoctrination is so ingrained that just exposing the truth, shall we say, is not enough. You've got to think the truth.
Well, exposing the conspiracy is scratching the surface.
Okay.
Exposing truth is quite unsettling and quite potentially dark in some ways.
Yes.
And that journey that we all have to go through is that exploration of truth. That's really, in a sense, what it is. It's the discovery of natural law and understanding how we have to align ourselves with the universe.
Yeah, but what a time to be doing it. I mean, you know.
Well, now it doesn't take that long to start that process. The effect could be massive.
Yeah.
If sufficient numbers of people started on that journey.
Yes. No, and what I suppose what with John doing what he's doing, and we've all gone through this very troubled time, and we're all thinking, was it necessary? Was it overreach? Are we happy about it? And it happened to the whole world all at the same time. And so therefore, what a great time to be looking inwardly at ourselves and common law, natural law, constitutions and all of that. And if the whole world is doing it now, this is such an amazing time to be doing it, because it's going to trickle out everywhere, which must get the other side slightly worried. We're sort of over time now. Is there anything else you wanted to add to any of this?
John, anything else you want to add?
I would only say one thing, and that is, as Will's just put it, this is much, much more than about just getting out of a fine or not paying your electricity bill. It's all to do with the world that we actually create because of the way that we think and act every day. And that's what it's all about, really.
Yeah.
And therefore, it's not about just getting out of trouble.
No, exactly. Just John said, it's not the firefighting; it's the root cause.
Yes, it's about taking that action when you're not in trouble.
Right.
That's the key. Yeah.
Brilliant work, gentlemen. Thank you so much for coming and bringing this, and we must continue to do this every few months, because I think people, it just trickles in, they get a gleam of it and they think about it, and then another one just reminds them, because we've all got so busy lives and we're trying to sort of fit all this lot in. It would be great. But meanwhile, John, down under, good day there, down under. Thank you so much for what time is it where you are? We're recording this in the morning.
It's 6:15 now, so no worries, Cobber.
That's all right, not too bad.
Fantastic. And so thanks to John, and thank you, Will. Will and I will be sharing a panel at the Better Life Conference in June in Bath from the 1st to the 4th. Can't remember what day we're on. So no doubt we'll be bringing this up there a little bit, talking about that.
I was hugely relieved to find out that, Richard, you were going to be on the panel with me.
It should be a laugh, shouldn't it?
It should be brilliant. And we've got some great people on our panel. I'm so honoured, actually.
Andrew Bridgen.
James Corbett, Andrew Bridgen, and Catherine Austin Fitz as well, who I actually haven't ever met. Actually, I'd love to meet her. Looking forward to that.
I'm very worried about it because there's a lot of people there I've vaguely heard of or have not heard of and should have heard of.
I'll introduce you to all of them, and yes, I'll give you the lowdown beforehand.
Anyway, ladies and gentlemen, getting a bit self-indulgent there, but thank you to John and to Will, and it's been an absolutely brilliant discussion. It's fantastic to find out what's going on the other side of the world, because we've all seen those pictures of how abusive the government has been to our fellow friends down below, and that has just been awful. The last place I thought Australia would be like that, but there you are. So John, thank you so much. Will, thanks a lot. I will be back again with another interview and another time, so do join us again. Don't forget to check, all the links will be in the description. But from all of us here, if you can find the off button, bye-bye.